My Lord, I left Ford and McHugh without making one further small point,
Right.
which would be that in our submission on the Crown's approach in this case, there should have been tax on going in, so to speak, in Ford and McHugh, as well as tax on the pension when it was paid. Whereas we say on our approach, whether it's national insurance contributions or income tax, there's no tax going in, but tax going out in the Ford and McHugh case, and indeed in this case, no tax going in, but, of course, many possible tax charges lying in wait under the provisions affecting employee benefit trusts. Your lordships have seen Brumby and Milner, and the charges can arise. Also under the loan provisions and the benefit in kind provisions, all sorts of charges could arise at a later date.
Do we have somewhere set out all the charges, the pitfalls that are waiting?
Well, no, you don't, my lord. I mean, if it would be helpful, I could very happily
Well, if you
sketch
don't
them
mind,
out.
I think I would find it quite helpful to see.
Well, there's quite a lot of stuff on.
What, a sheet of A4, would that be possible?
Yes, well, one sheet of A4, just to sort of...
Yes, I'll do it.
If you were to give us
My lord, I'd be
short
very
presentation,
happy to do that.
I would find that very helpful.
Yes, I'll get to work on that. May I turn next to Dextra, which is at volume 2 of the authorities, tab 29, and the page I want to refer to is MS 2045.
2045.
Now, I do so to make 2 points.
Yes.
One is really just a point of fact. If you go to the top of that page, it will be apparent, indeed, this is what it actually states. At the time the first contributions were being considered, the consultant, in the absence of finding any comparable companies, gave a wide range
Yes.
of the salary, etc. So they were thinking about allocations when the money went in. They may not have done it until 3 months later. But the second point, my lord, is this. We know, because further down the page, just above the letter H, that on the 10th of March 1999, subtrusts were created, and it occurs to one to suggest that that would have been a clear occasion of charge if my learned friend is right on issue 1 on his alternative liability. In other words, if it's the transfer of funds notionally to the subtrust, which could also give rise to a charge to tax on emoluments or earnings, why on earth didn't it do so in Dextra? So, my lord, in my submission, the learned friend can't really say, oh, well, I'll let Dextra be treated as rightly decided. On his view of things, it was wrongly decided. It is of some significance, I would submit, that although the deductibility point in Dextra was pursued to the House of Lords, passing my Lord Duberger on the way in the High Court, the emoluments point and the benefit in kind point were never appealed. Now, Dextra was very much followed in Sempra. A learned friend takes issue with the Sempra decision, as did the Inner House. The difference in Sempra, without going to it, if I can just state it, was that in Sempra they didn't have sub-trusts, they had mere allocations of an informal nature within an employee benefit trust. And the second difference is that they were created ab initio.
Well, in a sense, you don't have to deal with those differences, do you? Because Mr. Ghosh made it clear that he was saying Sempra was wrongly decided.
Well, that, as I understand it, is what is being said.
Exactly.
I'm just submitting that actually, if Dextra was rightly decided, so was Sempra. The only difference was that you had allocations instead of subtrusts, and that it was done straight away. There was, however, one point which my learned friend did fasten on, that he said in Sempra they had a choice. Now, That's an ambiguous word, because it may mean that they had a sort of offer which they were free to accept contractually. You can either have this money or you can have that, an allocation. What actually happened, I argued the case, was it wasn't quite put like that. There was consultation beforehand. If we were minded to give you a bonus, and it was to be divided in this form or that form, which would you prefer? Now, that, of course, is something which we find also with the executives here. They were given a chance to express a view, but that didn't result in their having any contractual right. So, in my submission, that aspect of Sempra doesn't, so to speak, undo the decision, which really marches on all fours with Dexter. It's pretty well indistinguishable. So that's all I have to say on Dexter.
Thank you.
Now, I'm going now to deal with Aunt Agatha, because it clearly is something of a conundrum, but I start by making this point, if I may. In several of the cases that have been examined in the court over the last 2 days, one sees an employee being offered a mixture of cash plus some kind of benefit. And we say, in those circumstances, the proper course is to look at the benefit and decide whether it constitutes money or money's worth or not. But what the employee is offered is something which, from his point of view, is a valuable advantage, which is worth having as an employee, whether it's a suit, the use of a car, a pension, or, as in this case, the benefit of a subtrust for chosen beneficiaries and the ability to take loans. So there are all cases, so to speak, where what's available is of some use and benefit to the employee concerned. And those sort of cases, I would submit, stand apart from what I suspect the Aunt Agatha case is going to be, where there might be some benefit, possibly, which one might extract from giving money to Aunt Agatha, but broadly speaking, one is simply saying, I don't want all this money, let someone else have some of it. Now, taking an Aunt Agatha case, the possibilities are as follows in my submission. First of all, it's reasonable, I think, to assume that any initiative to give something to Aunt Agatha is going to come from the employee rather than the employer, because the employer, one assumes, won't be very concerned about Aunt Agatha, it's the employee. If the employee is actually entitled to a salary and then says, I want part of it to go to Aunt Agatha, that's obviously caught by Smith and Stretton, and one need say no more. If Aunt Agatha is a dependent of the employee, that makes her part of the employee's family as defined. It's defined in section 721 of ITEPA. It includes spouses, children and their spouses. It doesn't include grandchildren, uncles and aunts, for example, and it does include dependents and members of a household. So if Aunt Agatha was a dependent, then there would be a benefit in kind charge. But my submission would be that the tribunal would need to look very closely at whatever was going on between the employer and the employee, and could easily conclude, as did Dr. Poon in this case, that the employee had it within his grasp, so to speak, or her grasp, to receive, let us say, £50,000, and then engineered an arrangement under which part of it went to Aunt Agatha. In those circumstances, my submission would be that it would be open to the first-tier tribunal hearing the appeal to say that that was really a Smith and Stretton case, because it was the exercise by the employee of his salary rights over his salary rights which gave Aunt Agatha the money. Now, it may be said, well, if that's the case there, why isn't it the same here? And the answer I would give is that the deal offered to the footballers was not a deal which entitled them to a salary which they could divert somewhere. There wasn't any such agreement. The club couldn't afford it. So that's the distinguishing feature. And that was really, my submission, the basis of the first-tier tribunal's findings, which I've emphasised on many occasions at paragraphs 205 to 208. And one sees Lord Doherty in the upper-tier tribunal. It's at paragraphs 63, 64 and 68, MS 2556 to 2557. One sees him emphasising that very point.
Sorry, where was that again?
It's 2556 to 8.
Thank you.
If by any mischance Aunt Agatha had so far escaped any taxation, it is, I suppose, worth pointing out that if I agree to pay someone at the rate of X thousand pounds a year while someone else is employed, that does actually constitute a taxable annual payment. I mean, that's not, of course, quite the same as it being charged to tax as earnings, but that would be taxable in the old days under case 3 of Schedule D as an annual payment, and nowadays it would be taxed under Section 683 of the ITOIA, that's the 2005 Act, ITOIA 2005. So were Aunt Agatha to escape everything else, she wouldn't escape completely. And I suppose it's worth adding, if the employee had the ability to benefit from those annual payments, he could be caught under the settlement provision, so he would have to pay the tax. So it wouldn't be, if I may respectfully say so, entirely plain sailing on any footing. Now, my Lord, I turn now to benefit in kind. There are many points that could be made, and in my submission, it is not, if I can put it that way, ideal that a somewhat complex point. My learned friend wants to keep it simple because, of course, he doesn't wish to be embarrassed by the fact that he's raising a complex point at the last minute without any assistance from the courts below. But one can make 3 short, sharp points. If we go to section 154 yet again in volume 1 of the authorities at page 1205, it is clear that in subsection 2, after the enumeration of the benefits to which the section does apply, we have exclusions. And one exclusion is any benefit chargeable under section 160. And section 160 is available to us at MS 1210, and it talks about beneficial loans. And the main requirement for liability is in subsection 1, where you have a person in employment, and there is outstanding for the whole or part of a year a loan, whether to the employee himself, that was the case here, of course, or a relative, of which the benefit is obtained by reason of his employment, and no interest is paid on the loan for that year, or the amount of interest paid on it for the year is less than interest at the official rate, that changes from time to time, an amount equal to whatever is the cash equivalent of the benefit of a loan for that year shall be treated as emoluments of employment and accordingly chargeable to tax under Schedule E. Now, it may be asked, do those provisions apply in the present case? Now, my learned friend didn't address this in dealing with benefits in kind. He made a passing reference yesterday to these not being cheap loans, but that's not the point. These loans, precisely the same kinds of loans as we have here, were the subject of a first-tier tribunal decision. I happen to know, because I had to argue it, it was rather a hopeless case, I thought, for the taxpayer, but it's called Leeds Design, and it's reported in the UK first-tier tribunal reports for 2014 at page 9. And it was held in that case that loans which were identical to the loans here, it was another Baxendale Walker scheme with exactly the same kind of loans, with no interest being paid to start with, but a payment at the end, were caught by these provisions. I haven't, I'm afraid, brought the case with me because I wasn't sure quite how the benefit in kind argument was going to work, but that's the reference. Now, the question is this.
Could you just give me the name again?
I'm so sorry?
The name of the case?
Leeds Design. Actually, it's a bit longer than that, but I've forgotten the full title. But
Leeds.
Well, perhaps you can let us have a note of it.
Yes,
Thank you very much.
But the question really comes down to this. Subsection 2 of 154 excludes benefits chargeable under inter alia section 160. Now, in this case, loans were invariably made. The only exception was Mr. Newman. Every other employee took the full amount of their fund as a loan. So the loans exhausted the entire fund in the sub-trust. One would think, I mean, this is not covered by authority, which is, again, one of the difficulties of debating this point for the first time at this level, but one would think that where the whole of the trust fund was lent, and that gave rise to a charge under section 160, that would totally exclude the same fund being charged a tax under section 154. I say that because under the provisions of section 160 and schedule 7 that goes with it, there can be subsequent events like the release of a loan, which can result in the totality of a loan being charged to tax as income. Now, if that possibility existed and there was also a charge on the whole fund under section 154, one's instinct at least would be to say this doesn't look right. So that my argument would be that in the circumstances of this case, any 154 charge, and the same applies to section 202 of ETEPA, is totally taken out by the fact that the loan provisions take precedence. Now, the point about the loan provisions is that they do give rise to an annual charge to tax on at the official rate if you don't pay any interest. That charge is not subject to pay as you earn for the simple reason it doesn't involve any payment. There's no payment of any sort at all. And therefore could not be the subject of the Regulation 80 determinations against which an appeal is being made in the present case. I should say that I pointed out to the first-tier tribunal many years ago now that I couldn't see why there wasn't a charge raised under these provisions. But Mr. Thompson and those instructing him simply said, we're not interested. We say these are earnings or emoluments, and that's the end of it. So the matter wasn't pursued. But in my respectful submission, that's the short, quick answer to the proposition that there is a benefit in kind charge under the general benefit in kind provisions, either 154 or the equivalent provision in ETEPA, which is section 201 and section 202. Should I perhaps show the court the ETEPA provisions? Perhaps I should.
Well, not if it's exactly the same.
I mean, they're not exactly the same, but they're very similar. Section 201 is at MS 1317. It's worded slightly differently. This chapter applies to employment-related benefits. Then subsection 2 defines benefit, but then there's a definition of excluded benefit. See section 202, and you go over the page to 1319. A benefit is an excluded benefit if any of chapters 3 to 9 of the Benefits Code applies to the benefit, and it's chapter 7, which deals with loans. The wording I would submit of ETEPA is clearer, perhaps, than 154. It would seem that if the whole of a fund is used to make loans, then that takes the whole thing out of section 201. But it's essentially the same. Now, if attention did fasten instead on section 154 or section 201, if it said, well, you are within those sections in principle, our first submission would be, no, we aren't. What was created in this matter by way of subtrusts were rather different. They varied from case to case. There are 108 of them. But the court has seen this morning in the argument that was going on about the protector's powers, the general way in which they were drafted. For example, it wasn't uncommon to be the beneficiaries to be my widow or my wife living at my death and my children. In each case, I think, the qualification living at my death applied. It will be apparent that trusts in those forms don't exhaust the entire beneficial interest of the subtrust fund. The beneficiaries might not survive, and you will recall that there were provisions enabling the appointment of replacement beneficiaries were that to happen. Now, who would those replacement beneficiaries be? They could be grandchildren, or if the family had died out entirely, it might be someone completely different. In other words, you couldn't say that the subtrust on creation could only benefit members of the employee's family. Now, if you couldn't say that, for example, if, say, the other members of different families or grandchildren or uncles and aunts might creep in later, then the benefits wouldn't be given to the family, they'd be given to non-family, and therefore will be outside section 154. And it's pointed out to me helpfully by Mr. Dunlop that in one case it was children and remoter descendants who were the actual name beneficiaries. Now, remoter descendants are not part of the family as defined. So it's not possible in my submission to say, well, this was a benefit for the family, because in every conceivable circumstance, the money would have gone to one or other member of the family. But even if you could say that, even if you could, it's necessary to go back to Dextra, in my submission. That's volume 2, again, at divider 29, because Dr. Avery Jones and Judge Sadler did consider, even in a situation where only members of the family could benefit, whether the benefit in kind provisions applied. Now, my learned friend dismisses Templeton and Jacobs as being pretty irrelevant because it's all about loft conversions and looks as though it's many million miles away from the facts of this case. But the point which was weighing with the special commissioners, and one has it at MS 2044, is the possibility of double taxation. Suppose I create a sub-trust for the members of my family, and then, for example, the sub-trustees buy a house, and one member of the family lives in the house. Then the trustees buy a car, and someone has the benefit of the car. Those are actual benefits which each occasion a specific charge under the benefit in kind provisions. Or, for example, I can think of numerous examples. The point at issue is that if you impose the tax charge on day one on the creation of the fund, does that eliminate subsequent charges on actual benefits provided out of the fund later? And Dr. Avery Jones and Judge Sadler said, well, it didn't seem right. And the general thrust, they said, this is paragraph 11 on page 2044, the general thrust of the benefit in kind legislation was to look at actual conferments of actual benefits, not potential possible benefits that might be conferred. And that being so, the creation of the fund in that case didn't give rise to a benefit in kind charge. So that's a second reason in my submission for there not being a benefit in kind charge under the general or residual charges. If there were a charge under the general or residual benefit in kind charges, we would accept, I think this was in dispute at one point, we would accept that there would be a pay-as-you-earn liability. But it doesn't arise under the loan charge. Apart from that, my learned friend's points on pay-as-you-earn are not disputed either. So all that learning on pay-as-you-earn, which you had this morning, very competent elucidation of a somewhat boring topic, that needn't concern the court. So that brings my submissions to an end, and I would respectfully ask the court to allow the appeal on issue 1 and dismiss the cross appeal on issue 2. And no doubt, if either side are putting in fresh bits of material, it would be sensible for us to exchange them in case we have wildly different views as to what's being submitted.
Yes.
And that brings me to the end, my lord, unless there's anything else I can usefully deal with.
And your position on the benefits issue, that he shouldn't be allowed to take it at all, is that right?
I'm sorry, your
Your position on the benefits in kind issue,
Yes.
although you've argued it, you're already saying he shouldn't be allowed to take it at this level at all.
Yes.
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 Yeah.
Yes.
Well, thank you very much indeed. Well, we are very grateful to counsel for their submissions. They're all submissions in this somewhat technical and significant case. We are also grateful to those who prepared the written cases and had involvement in that. We will consider our decision and let you know it in due course. Thank you all. And we look forward to hearing any further written points that I think it was more information we were looking for than anything else. Is that right?
I don't know, unless my Lord Conworth is really interested. I'm not sure he is.
Well, I think now that PAYE has happily dropped out of the picture, I think I can forget about that.
Is honourably excused.
And so the only point is just
Yes,
having
I've got to do my one, yes.
but yes, then of course.
That's fine. I just wanted to make sure I hadn't missed something. Good. Very well. Well, then we will adjourn now and let you know our decision in due course. Thank you all very much indeed. The court's now adjourned.